كلية الفقه الحنفي تقدم.
السلام عليكم ورحمة الله وبركاته. الحمد لله والصلاة والسلام على سيدنا Muhammad وعلى آله وصحبه أجمعين. أما بعد. So, dear brothers and sisters, welcome to the second lesson of this chapter on qismah and division, as we were discussing. May Allah subhanahu wa ta'ala bless you all, keep us in the prayers of for White Thread and for Wise University. And today what we're going to be discussing is that how should the judge deal with different petitions and claims for division, and what does he have to take into consideration, and in what cases is he allowed to do the division, and where he's not allowed to implement it. So that's what we're going to be discussing today, inshallah, and then maybe move on to some other discussions regarding how to how to divide different things. I think we've got a good understanding though already from the first lesson, inshallah, of how these things usually work, inshallah. So just to carry on with what Imam Quduri is saying, then وَإِذَا حضر الشركاء عند القاضي وفي أيديهم دار أو ضيعة أي أرض ادعوا أنهم ورثوها عن مورثهم فلان لم يقسمها القاضي عند أبي حنيفة. Right, so what's going on here is that a number of partners, shuraka, they present themselves in front of the judge. They have in their possession, they have a house. It's in their possession, meaning they have the deeds or something, right? Or they're living in it, or they have the key to it. Or they have a piece of land, right? And they show that they have the land in their possession. And their claim is that they are the inheritors of this land. And they got this from their father or uncle or whoever he was, the muwarrith, the deceased who has passed away and left inheritance. So according to Abu Hanifa, the judge is not allowed to divide it among them on this basis. We will discuss the details of this in the lessons, inshallah, why that's not allowed, he says. The reason for this is very interesting, and it is based on a technicality which I think will be useful for us to know. So I'm just going to read to you what Imam Maydani says. Imam Maydani says, لأن القسمة قضاء على الميت. In this case, if he went through with the division for them, then he is actually passing a judgment against the deceased by him dividing up the assets on these inheritors, among these inheritors for them. Imam Abu Hanifa doesn't allow it because he says that this is a judgment against the mayyit, but the deceased is dead and surely the inheritance moves on. So why doesn't he allow it? So again, as I said, this rests on a particular technicality which we need to understand. So then he says, إِذِ التَّرِكَ مُبَقَّاتٌ عَلَى مِلْكِهِ قَبْلَ الْقِسْمَةِ. Until it's actually not divided. There's a really interesting fine point here. That until the asset is not divided, it is assumed to be the ownership of the deceased, in one sense. In another sense, based on some hadith and so on, what we learn is that as soon as a person dies, their assets become the property almost, right? The property of their inheritors, whether the inheritors know or not. So it's like it just transfers in cyberspace. It just transfers in Allah space, what Allah subhanahu wa ta'ala considers to be, whose. It's already gone to the gone to the inheritors. So here the inheritors, they're just claiming it, divide it for us. So said no, until it's not divided, because it's a whole block and nobody can lay claim to all of it because they all have a shared connection in it and a shared ownership of it. If there is any liability with regards to that particular position, with that particular asset, who's going to take up that liability? Also, another thing is that how do we know if the owner who has died now, the deceased, had some debts and they still have to be paid from here? If these guys, these inheritors, had not come in and said, this is our inheritance and this is how we want it to be divided, and they just said, this is ours, belongs to all of us, we can't decide on how to divide it. They don't say where they got it from, they just lay claim to it. Then in that case, the judge would not have this issue. But they've added the aspect that this is inheritance and it's not yet been divided. So it's in this hybrid position of still being considered. So that's why he uses the word in Arabic, mubaqqatun ala milkihi, as opposed to baqiyan or baqiyun, right? Or baqin rather. It's mubaqqat, that it's been treated as the ownership. It's been, you can say, forcefully retained under the ownership of the deceased before it is divided. Okay, so then just divide it. So what's the next part? Then he says, بدليل ثبوت حقه في الزوائد كأولاد ملكه وأرباحه حتى تقضى ديونه منها وتنفذ وصاياه. Right. So how do we prove that it's still ownership? So it's almost like they're going to use the consequences to justify whose ownership it is. So they're going to say that, okay, let's just say that there's a house that was left by the deceased, it hasn't been, and he's got 5 or 6 inheritors, his wife, children, etc., or husband, wife and children, husband and children, and it hasn't been divided yet. Now what happens is, who takes the rental income from there? Or let's just say he had animals, a flock of sheep or horses, and they had offspring. Whose are they? Right? So clearly they're going to be linked back to the assets to him. So it's like he left behind all of this, even though they were born after he died. Likewise, any income that was generated from a rental property or something, such that if he has any debts, that is the income, that is the wealth, those are the assets from which his debts are going to be paid, right? Where else is his debts? Remember, debts come before any inheritance. So that's what he's going to do. He's going to have to pay for the inheritance from there, and it's not going to be from anywhere else. So that's how it's going to be. So بدليل ثبوت حقه في الزوائد, as I mentioned, وتنفذ وصاياه, and if he has made any bequest for anybody, then up to 1/3, whatever, that has to be also applied from whatever he's left. So there could be so many, essentially, in other words, saying that there's just so many things that could still be done, and we don't know if the judge was to actually distribute all of this among the inheritors, and then tomorrow somebody comes along and says, oh, but he owed me money, then the judge would probably get into trouble for not doing this. So he's not allowed to divide anything until they figure this out, because he is making a judgment against the mayyit, which is not allowed. وَبِالْقِسْمَةِ يَنْقَطِعُ حَقُّ الْمَيِّتِ عَنِ التَّرِكَةِ. As soon as he divides it, it becomes everybody's property, because remember, that is when it becomes their property. After division, it becomes their property. He is going to be the means of it completely transferring to them. So it has, in a sense, transferred to them, but there's so many rights that could have been associated with it, we don't know about them yet. But if he divides it all, it goes to them, it becomes more difficult to get back, even though they should not have received all of it if there were some debts, for example, that the deceased owed. حتى لا يثبت حقه فيما يحدث بعده من الزوائد فكان قضاء على الميت. Right. So saying that, let's just say that the judge divides it, and then after that there's offspring. So obviously the offspring would then be the ownership of whoever gets that animal. It's not going to be the deceased. So the deceased doesn't get the benefit. So it's like we're going in circular, it's like a circular argument here. Why does he need to benefit? He's dead already. So it's just a way of looking at it. It's just the way of looking at it. That in this particular scenario, the judge is not allowed to divide anything if they claim it to be inheritance. Because essentially what that is we haven't received our inheritance yet. Can you divide this between us? And the judge, when he does that, it means that he is transferring the partial ownership or the ownership that had been retained for the deceased over to them. And now there could be an issue. There may not be any issue, but it's just seen as he is depriving the mayyit. It's just a legal way of looking at it. So that's why he says it's not allowed. Hopefully that's clear. So just to kind of clarify and summarize it, anything left by the deceased until it's actually not properly fully divided remains his property in a sense, though it becomes inheritors property because the maid really can't do anything with it, but it's still legally considered to be his in a sense. So that's why the rightful inheritors don't pay zakat on it. Let's just say that a house was left or cash was even left and nobody divided it yet, the testators did not divide it yet. There's no zakat on that, even though it actually kind of becomes theirs and they have a rightful claim to it. There's no zakat on it because the mayyit is dead. He's not living, so he doesn't have to pay zakat, but the money is still there. So in many things, it kind of is like it's in that hypostatic state. It's neither here, neither there, but legally it's treated as still the owners. So if the judge is to make that decision to divide it, it means that now, if there was an outstanding debt or whatever, he has already judged against the mayyit, which means the deceased person, and he's not there to defend himself, essentially, right? I know it sounds a bit weird in that sense, right? That he's not there to, so what's the issue? So he says, فَكَانَتْ قَضَاءً عَلَى الْمَيِّتِ. So that's not allowed. فَلَا يُجَابُونَ إِلَيْهَا بِمُجَرَّدِ الدَّعْوَةِ. Okay, so what was all this for? There's a very simple way to deal with it, right? This is a very simple way to deal with it. The other big part of this that I have not yet mentioned, right, which the next part hinges on, is that because they've said that this is our inheritance from, our father or whoever it was, the judgment would then go against the father. What they would have to do first to make this right, and you're wondering, okay, how do you make this right, is that they have to establish that he died. So I left that in suspense because that's the next part, right? They just have to, فَلَا يُجَابُونَ إِلَيْهَا. So they will not be responded to. Their claim will not be entertained, essentially, بِمُجَرَّدِ الدَّعْوَةِ, just by that claim that, hey, this is our inheritance, please split it up and divide it for us, right? Until they do something. That's why Imam Quduri then says, حَتَّى يُقِيمُ الْبَيِّنَةَ عَلَى مَوْتِهِ وَعَدَدِ وَرَثَتِهِ. They'll have to establish two things, right? Until they establish evidence, proof that he has died on his death certificate or something that, is proves beyond doubt that he's not there anymore, and also the number of his inheritors. Because again, there could be 3 inheritors coming to ask that division. There may be 5. There may be 2 missing. So they have to establish both of those things. وَيَصِيرُ الْبَعْضُ مُدَّعِيًا وَالْبَعْضُ الْآخَرْ خَصْمًا لَهُ عَنِ الْمَيِّتِ. Now, this is another strange thing that they have to do, because they have to establish some of those inheritors will act, because it has to essentially take place, and it has to proceed through the court like a proper dispute with a claimant and a defendant. So the defendant's dead. So what they'll do is they'll put some of the inheritance as defendants and some of them as claimants, just to establish the procedure to get it done. So some of them, or one of them at least, will become the claimant, وَالْبَعْضُ الْآخَرْ, and another one will become his adversary on behalf of the deceased, because that is a possibility that they can do that. And so then the way, because you can't listen to evidence without a case. Evidence, as we learned earlier in the earlier chapters, evidence is only presented after the case has come in. A case has been launched, lawsuit is there, the claim is made, the judge asks the other side. So all of this procedure has to play out. So it can't be one-sided. So they have to literally put it up there. They've got the proof anyway, so it's all going to go through. So one of them will say, okay, what do you call it? My father's estate is here. He has died. We want to claim that because he has died, we want to establish that he has died, and because of that, we need the inheritance divided among us. And the other guys will say, well, we don't have any proof to the contrary. Okay, we don't want to say anything to the contrary. So, or they could just accept, and these guys can provide the evidence if they don't accept, right? And once they provide the evidence, or even if the others agree, it's all done and dusted. But in this case, they would have to actually provide evidence that he has died, and also that they are the full waratha, right? And then it will all take place. Sahibain, the Imam Abu Yusuf, Imam Muhammad, they say, وَقَالَ يَقْسِمُهَا بِاعْتِرَافِهِمْ. Look, they have it in their possession. So just by them confessing that, look, we are the inheritance, that's enough for the judge to let it go, to divide it among them. He doesn't need any more, because he says لأن اليد دليل ملكي, the fact that they have possession of it now shows and indicates that they own it. ولا منازع لهم, and there's nobody to, they don't have an adversary, they don't have anybody who conflicts with them, who disputes this idea or who claims it. There's no competition in this regard, right? فيقسمها كما في المنقول. So just like in any movable possessions, this land or whatever would also be divided. The judge can just divide it. ولكن يذكر في كتاب القسمة أنه قسمها بقولهم. Right. So, however, the way he's going to record that, the way he's going to put it down in the books, just so that it becomes future proof in that sense, and it becomes quite clear how he did it exactly, that he will mention in the record of this division, the official record that he has, that he has, this Sahibain saying, by the way, that he has divided among them just based on their statement. It wasn't done with a full court case, with a lawsuit and evidence and, with an adversary. It was just done according to their own confessions or their own demands, right? So that way, the benefit of that is that if there did happen to be another partner, another inheritor, this won't be, because remember, once a case is ratified, then it becomes very difficult to break it, right? And it becomes more complicated. Now, since here that they have not done it through a full systematic, method, then he just writes it down that he did it based on their opinion, and that way, legally, it will not be looked on as having judged against a third party, because they may have two more inheritors that weren't there, and the judge just divided it between the three of them, and there's two more that come out the next day. So this won't be seen as a final judgment, right? If there is anybody that comes out. Now, if there's nobody that comes out, then it's a final judgment. They can just treat it because there's nobody to conflict with them. La ilaha illallah. Al-Imam Jamal al-Islam in his commentary of the book says, As-Sahihu qawlu al-Imam. The sound opinion is Imam Abu Hanifa's opinion, which Mahbubi, Nasafi, Sadr al-Sharia and many others have relied upon. Okay. وَإِذَا كَانَ الْمَالُ الْمُشْتَرَكْ مِمَّا سِوَى الْعَقَارِ. Now, what happens if it's not a piece of land? It's rather a movable object. It's a car, it's gold, it's cash, something else. وادعوا أنه ميراث أو مشترى أو ملك مطلق وطلبوا قسمته قسمه في قولهم جميعا. Now remember, this is the strictness that Imam Abu Hanifa, and this very rigid opinion that he had, was only regarding pieces of land or buildings or assets that are immovable, right? In anything else, it was easier, right? And this is where he mentions that, that the Sahibain and Imam Abu Hanifa, all three Imams, are all agreed on this fact, that if a group comes and they say that, can you please divide this asset between us? And they say that it is mirath, meaning it is inheritance, but it's a car, right? Or it's something else. It's some other assets. It's a business and so on, right? Meaning it's a service-based business or assets or whatever it is, but it's not any, immovable assets, right? Or now many other things are very similar to this. Or it's something that they have purchased together, but they don't know how to divide it. Hey, we purchase this this wholesale items of fruit, because they all do business and they bought this whole, consignment, and they don't know how to split it up, right? Or milkun mutlaqun, or they just claim that this is ours. They don't say how they got it. Milkun mutlaq here refers to that they just claim that this is ours. They don't tell you where they got it from or how they got it, okay? Because until now the discussion was they got it from the inheritors. And the second point I made in this particular scenario was, or they bought it, right? The third case is, no, it's ours. They don't mention, so the judge doesn't have to ask, right? And they just want it to be divided. So all they need is assistance on, because they can't do it, is to divide it. قَسَمَهُ فِي قَوْلِهِمْ جَمِيعًا, according to Abu Hanifa, Imam Yusuf, Imam Muhammad, all of them will say that yes, just based on their opinion, he will divide it between them. لأن في قسمة المنقول نظر الحاجة إلى الحفظ, right? It's better to do that because you see, when it came to it's better to do that because there's more protection there's more protection and security for the assets in this, at least then people get it. So if there is somebody that comes up later on, at least we can charge them again and take back some part. Whereas when it was when it was land, Imam Abu Hanifa says we don't need to. The land can last on its own. Nobody's going to take any of it. Meaning the land does not get old. The land does not recede. The land does not diminish. Whereas when it comes to products, you have to do it as soon as possible. Otherwise, somebody's going to consume it, use it, eat it up, or whatever it is, and it will diminish and it will disintegrate, or it will diminish in some way. So that's why he said it's better in this case just to divide it on their statement, and then if it comes out wrong, then they can make somebody pay a compensation or whatever the case is. Right? That's essentially what it is. Right. وَإِنْ إِدَّعُوا فِي الْعَقَارِ أَنَّهُمْ اشْتَرَوْهُ وَطَلَبُوا قِسْمَتَهُ. Now, that same first case scenario where Imam Abu Hanifa was very rigid and said that no, he can't divide between them when they claim that it's inheritance, a piece of land. So now they're saying that if it is a piece of land or an asset of that sort, a building of some sort, if they came and claimed instead of that inheritance, if a group of people said we bought it. Now this isn't to say that they're going to make this up. This is just say that if it was a case where they'd actually purchased it and they don't know how to divide this big, huge storehouse or this big piece of land or this big estate, they just don't know how to do it. They want the judge to do it for them. He will do it. He will do it, right? So Imam Abu Hanifa was only strict when it came to mirath, when it came to inheritance, not if it was a purchased item. So I just want to clarify again. The first case was only about inherited items. Sahibin were like, it's okay. He can make the division. Imam Abu Hanifa said no. If it's inheritance, they have to establish that he's died and that they are the inheritors, right? That was one particular issue. Now, if it's any movable object, anything less than an estate, then they all agree that the judge can make a judgment. So there's one case left, which is that if it's a piece of land, but it was not inheritance that they were claiming, they were just claiming that we bought it, then again, Imam Abu Hanifa is with the Sahibain in this case, that yes, the judge can go ahead and make that judgment. That's okay. لأن المبيع يخرج عن ملك البائع وإن لم يقسم. Because in this case, it's very different from the inheritors case, right? So I'll explain that. See, in this case, he's saying that this is actually very different. In this case, he's actually saying that this is very different from the case of the inheritance. Because in the inheritance, he had that technicality that until it's actually not divided, it's still the ownership of the deceased. Whereas if I sell you something and we've done the ijab and qabul, which means that we've done the offer and acceptance, I haven't given it to you, but it still becomes yours. It becomes yours, right? It actually becomes yours. It's no longer considered mine, even though I'm holding on to it and I haven't, I refuse to give it. It becomes yours. So that's why he's saying لأن المبيع, because the sale item comes out of the ownership of the seller, even if it has not been divided. فلم تكن القسمة قضاء على الغير. So technically, if he did divide it, right, it would not be a judgment against a absent person, because it's no longer the seller's. He sold it already. And so وإن ادعوا الملك المطلق. On the other hand, if they claim just general ownership, I think I've already explained this to you, that if they just claim general ownership, hey, we own this is ours, you just need to divide it for us, can you divide it, we've got a disagreement about that. لم يذكروا كيف انتقل وَلَمْ يَذْكُرُوا, and they don't mention how it came to them, how it becomes theirs, right? And it's in their possession, right? قَسَمَهُ بَيْنَهُمْ أَيْضًا, he'll also divide it between them. I've already explained this issue to you, because there's no possible adversary in here. There is. I mean, they could have stolen it, right? But then that would become very clear afterwards. But in this case, it's theirs. There's no report of stealing or whatever. He will, and if it's stolen, I mean, I don't think they'll go to the judge anyway, right? لأنه ليس في القسمة قضاء عن غيره. Again, the technicality, according to Imam Abu Hanifa, the Sahibin will be fine with it anyway, but according to Abu Hanifa, he's saying there's no judgment against a third person, against an absent person here, right? Because there is no absent person. There's nobody to come and, be their adversary. فَإِنَّهُمْ مَا أَقَرُّوا بِالْمِلْكِ لِغَيْرِهِمْ. Because they're not saying that it was somebody else's. In the case of the inheritance, they were very clear that, hey, this belonged to our father, but we're the inheritors and he's dead. So, give it to just divide it between us, because we can't do it ourselves. قال في التصحيح هذه رواية كتاب القسمة وفي رواية الجامع لا يقسم حتى يقيم. So there is a difference of opinion here. Qasim ibn Qutluha mentions, right, after his research, that according to the chapter of division from the Mabsut, Imam Muhammad's Kitab al-Asl, right, this is what he says, is that they can divide it, right? And but in his Jami, in his other book, it says that he shouldn't. So it looks like he had two views there, or separate views at different times. حتى يقيموا البينة أنها لهم. They have to first establish that it is their ownership. So they have to better prove that they got it somehow. So now what Hidayah says here is ثم قيل هو قول أبي حنيفة خاصة وقيل هو قول الكل وهو الأصح وكذا نقل الزاهدي. Now there's a further layer of difference of opinion over that second opinion from the Jami', which said that they have to establish, they have to bring proof, produce evidence for this. Hidayah says that it has been said that that is actually Imam Abu Hanifa's opinion. The earlier one is Imam Muhammad's, but this is Imam Abu Hanifa's opinion in particular. And another statement says that actually no, this is all of their opinion. So it is that second opinion, and that is the most sound opinion, that yes, they better establish proof in this regard, as well as Zahidi has stated. So there is some difference of opinion in this regard. Okay, وَإِذَا كَانَ كُلُّ وَاحِدٍ. So that Jami' referred to Jami' al-Saghir, by the way, the Jami' al-Saghir of Imam Muhammad. So one way to reconcile is that the second one is Imam Abu Hanifa's opinion, the earlier one is Sahibain's opinion. So Imam Abu Hanifa had the more stricter way that no, he has to establish evidence in this regard as well. But the other way to look at it is that no, this is actually all of their opinion, and that is the more rightful way of looking at it. Okay, وَإِذَا كَانَ كُلُّ وَاحِدٍ مِنَ الشُّرَكَاءِ يَنْتَفِعُ بِنَصِيبِهِ بَعْدَ الْقِسْمَةِ قَسَمَ بِطَلَبِ أَحَدِهِمْ لأن في القسمة تكميل المنفعة فكانت حقا لازما فيما يقبلها بعد طلب أحدهم. Now, let's just say that there were 5 owners, 5 partners. One of them comes and says, I want my share. Is there a democracy? Is this to be done in some kind of, majority view opinion, or is it that one person can ask for it and then he has to divide it? That's a very interesting question, I think, right? Because this is what happens, that there's 4 owners and they want to just carry on the business together, but one is having a lot of conflict with the others. He's got a different temperament or something. He wants out. The others don't want it because it's going to kind of dissolve the whole thing, and it might, sometimes you have like a row of stores or shops or something like that, and if you do divide something out, it just kind of affects the whole thing, because the whole thing together makes more money. But then this guy can't, one of them or 2 of them can't basically live with the others in that regard. Dealt with a number of cases like that. So he's saying that if there is just one person who comes and asks for a separation and division, and it is such that every one of them can actually benefit, on a different level, but can still benefit from their own portions, then the judge will divide it based on the request or the demand of one of them. Why? Because in that division, he is then allowing them to independently benefit. So I mean, of course, then once the one guy has it, the others, they can just carry on together. They don't have to physically divide it. It's just that it's become clear what is what. Or it doesn't have to be divided for all of them. They can just divide his. So we don't want ours divided. We want ours to. So let's give him his share. Decide what his share is. Give it to him with agreement. And then the other 4 shares, we don't want it divided. We want it together. We're just going to work on it together. So that could be fine as well. وَإِنْ كَانَ أَحَدُهُمْ يَنْتَفِعُ. So that's in the case of 5 people, right? If the case was just 2 partners. So then the case is very simple then, that one of them comes and says, I want my part. Now, if it is such that it won't lose its usufruct, it's not a silly demand where it's going to be wasted in a sense, then the judge will have to oblige and he will divide it between them. And each can then do their own business on their own little scale, right? However, if it's going to be such that if they do divide it, then one of them will continue to benefit because he has maybe 70% of the plot, and that 70% is enough to do something on, whereas the 30% is not enough to do anything on. They can only do it if it's kind of together. And so you might think, then isn't the other guy benefiting from the 70%? No, he is in a sense, but he only gets 30% of the proceeds. But if he separated it, he won't be able to do business on 30% because he's not big enough to do any business, for example. So the business can be done with 100%, and he makes obviously less. He only makes 30% of the profit, which is fine. The bigger shareholder gets more profit based on his proportion. But if it was to be split up, then it's going to be impacted where the 70 might still be able to carry on, but the 31 won't be able to carry on. Then obviously in this case, for one of them, usufruct is being lost. That's why he's saying that if one of them will benefit from the division because he's got abundant portion, وَالْآخَرْ يَسْتَضِرْ, whereas the second one stands to lose, stands to be damaged, essentially لِقِلَّةِ نَصِيبِهِ, because of lesser share of his. فَإِن طَلَبَ, so now it depends on who demands. فَإِن طَلَبَ صَاحِبُ الْكَثِيرِ قَسَمَ لَهُ. If the one with the majority, because the other guy's constantly causing him problems maybe, and you know, he just wants him out of the business, wants to do it himself now. So if the one with the more abundant portion demands the separation, the judge will divide and give him his 70%. لأنه ينتفع بنصيبه, because he can continue to benefit from his portion. فاعتبر طلبه, so his demand is going to be considered. لأن الحق لا يبطل بالتضرر الغير, because his right to take his 70 and make it independent should not be affected, right? Should not be encroached upon because of somebody else's potential harm based on a reality. Okay? وَإِن طَلَبَ صَاحِبُ, however, if it's the 30% guy who stands to lose, but he is the one who's demanding, then the other one doesn't mind carrying on together. In fact, wants it to be done together because he thinks that he can benefit the other guy. And the other guy doesn't understand, it's a bit foolish, maybe younger guy who just wants money, wants to sell it off or something, and just wants to do something that, you know, he can then fling the money or something. It could be one of those reasons. So the judge says, the book says, لَمْ يَقْسِمْ لَهُ, that he will not do it on the demand of the person that holds the lesser amount. Right, so let's finish off and then summarize. The reason is because he's asking for something that he stands to lose from. That shows that he's just being silly. He is just being stubborn. He's just being obstinate, right? And so interestingly here, it won't be divided. Subhanallah, it won't be divided. What they're going to do then instead? So one opinion is that you carry on benefit. If it's already making income and he's already getting a share, they can carry on. Otherwise, they will just split up. Like if it's, for example, 60% and 40%, then maybe 60 and 40%. That means maybe 4 days that guy will use it and 2 days this guy will use it, or something like that. You know, so they will put in turns or something like that. So essentially saying that because he stands to lose, in what he's asking. He can't be asking in seriousness. I mean, he can't be in the right frame of mind. So we're not going to do that. قال في التصحيح وذكر الخصاف على قلب هذا. Whereas Imam Khassaf has actually said that it's the opposite of this, which could make sense. That if it's the guy who gets a lot of the share, meaning the majority stakeholder, if he's asking for a separation, then the judge will not separate because it's going to harm the other guy. Whereas if it's the guy with less who's asking to separate, the judge will separate and divide it, because the guy, it's his right that was supposed to be preserved until now, and he wants to destroy it, and he wants to be damaged by it. So that's up to him. يعني لو طلب صاحب الكثير لم يقسم له ولو طلبه صاحب القليل قسم له, essentially. So that is what it says, that is the other view here, that's how it should be. So it's been transmitted in different ways. وذكر الحاكم في مختصري أن أيهما طلب القسم يقسم القاضي. Another opinion which Hakim has mentioned in his Mukhtasar is that any of them can request it and the judge will divide between them. It doesn't matter who's got more or less, or who's going to be harmed or not, makes no difference. In the Hidayah it says, also in the Hidayah and the Zahidi Sharh, that إن الأصح ما ذكر في الكتاب, that actually the sound opinion is what Imam Quduri had mentioned himself, which is that if the guy with the majority asks, then split it, and if the guy from the minority asks, then don't split it, because he's just being obstinate, right? So that's the end of our second lesson. Inshallah, we carry on. Keep us wise and white thread in your du'as. Assalamu alaikum wa rahmatullah.